Well, ladies and gentlemen, what I have to offer you in my amazing vlogs just gets better and better. And this one could be a total family court game changer. I mean on a national level. You will, of course, remember my blockbuster vlog called How to Challenge Cafcass and Hold Them to Account. In the last section of that vlog, I talked about the potential importance of lawfully recording Cafcass interactions and, if necessary, to use the recording or transcript of the recording in court proceedings, especially if there is a dispute. Now, I also promised that I would write to the CEO of Cafcass, their head honcho, the big cheese, the top dog, to get their absolute definitive position on us, the service users, recording interactions with Cafcass Family Advisors who are managing our cases. And folks, I have received that formal reply. And in fairness to Cafcass, this is a fully comprehensive response, far more detailed than what I had expected, which is indeed their definitive position. And it is quite literally dynamite. So, in this vlog, I am excited and delighted to share with you both my original letter and their full response. Indeed, better still, I am going to let you access and download both letters for yourselves as reference documents, which you can use and show to any Cafcass Family Court Advisor in your case if you wish to lawfully record interactions. But as always, before I dive in and reveal all, let me run my excellent introduction. I am Philip Kedge, a retired police chief inspector and the director of the Mckenzie Friend UK network. I am the founder of the national campaign of #LightNotHate to remove unnecessary and what I see as destructive family lawyers from the family courts, who all too often stir the pot of acrimony and hate for financial gain, engage in thousands of pounds of totally unnecessary work, leave people in crippling financial debt and have absolutely no duty of care to any child. How disgraceful is that? In all my vlogs, my views and opinions are entirely my own. Now, I must add a couple of important caveats. Firstly, you cannot record a court proceeding or in any court building. To do so is a criminal offence. Don't do it. I am talking about recording Cafcass interactions where it is lawful to do so, namely the Cafcass safeguarding phone call, any Cafcass visits or call to assist their Section 7 reports, and where you may be located away from a court building. Secondly, the Cafcass formal letter is marked private. However, in my original letter, I clearly stated that I would publish their letter of response. Hence, I will do so, but under the understanding that this is for your personal use only as a service user. The letter is signed by the head of the Cafcass legal team, and I have redacted their name and signature for their privacy, which I feel is fair and respectful. Lastly, I am not telling you what to do in your case. Whether you wish to use the information in this vlog is entirely a matter for you. I do not know your case, I am not your Mckenzie friend, and I am not telling you what to do. Nothing constitutes legal advice because you don't need legal advice or lawyers in the family court. I provide information as a Mckenzie friend layperson, as you may seek from an informed friend. With that firmly understood, let's push on, starting with my initial letter. In my letter, I asked 4 brilliant questions, which I will paraphrase. Number 1, Is there implied permission for any service user to lawfully record a Cafcass interaction, from which a transcript can then be used in family court if required? Number 2, if permission is implied, then is it agreed that there is no requirement to seek permission, although it would be courteous to inform the family court advisor that the interaction is being recorded? Thirdly, if there is no implied permission, how does the service user formally seek permission? And lastly, if permission is not given, how can this be challenged? Cafcass is a professional service, and I pose these questions on the basis that it is entirely appropriate for any service user to have an expectation of consistency and transparency across the entire Cafcass service. It should make no difference where you are from or who your Cafcass court advisor is. So without further ado, let's examine their formal letter of response. Firstly, from the outset, they didn't appear to understand my letter properly, because in paragraph 1 they state, "As I understand, you are seeking confirmation from Cafcass as to the legal position with respect to covert recordings of interviews undertaken by our staff in the course of their work." Now, my questions to Cafcass were not specifically talking about covert recordings. I was actually talking more about overt recordings, where you inform Cafcass that you are indeed recording and whether there is implied permission to do so. I am not advocating covert recordings, as that in itself may cause problems, which I will explain later. So, with that slight misunderstanding aside, things are about to get very interesting. Well, Cafcass explains that they have produced their own internal guidance, and just wait until you hear this. It states, "A parent or carer may ask to record, request that a family court advisor records, or may covertly record a telephone call or meeting with a family court advisor." So, straight off the bat, there appears to be absolutely no problem as a service user, either a parent or carer, recording your Cafcass telephone call or meeting. Cafcass even acknowledges that you can do it covertly, although I do have concerns about that, and we'll discuss it more at the end. It goes on to state, "We should always be transparent in our work, including being able to justify whatever we have said and written. The Transparency Project has issued guidance to parents and professionals on the recording of social workers, and such recordings may be admissible in court." Absolutely, and I say that we, as the service users, have the right to hold Cafcass to account in what they say and write. They have to at all times be able to justify their reports and recommendations to the court with full transparency. That is excellent news, and what I am suggesting is that the more that you are open and transparent in telling Cafcass that you are recording interactions, then the less likely they can object, and the more likely it should be admissible in court. The information in relation to the Transparency Project guidance is also interesting, and I have researched this lead. In March 2018, they did indeed publish guidance on recordings. Now, I am not going to go through that guidance today because I want to focus on the formal Cafcass response. However, I will include that guidance as part of the downloads to this vlog. Back to Cafcass, where they state, there is no reason to prevent a parent or carer recording their own interview, subject to any directions that the court may give about this if the Family Court Advisor decides to refer the issue to court for direction. So, what this appears to tell us is that whilst we, the service users, can record Cafcass interactions, the Cafcass Family Court Advisor may refer it to the court for directions. Personally, I don't have a problem with that. It provides sensible checks and balances for both parties if needed. So what do Cafcass say about their actual protocol? This next section is very informative. If a recording is made, the Family Court Advisor should inform the parent or carer that they will include in their report that the interview was recorded. The other party would be aware that a recording exists and could make an application to the court to have a copy disclosed to them or to listen to it in evidence. There is no guarantee that the court would order disclosure. How fascinating is that? So Cafcass are suggesting that if you record their interaction, the other side will be made aware in their report so that they can potentially request a copy. So does that mean that the other side can try and seek a copy even if that recording is never used? If that is possible, it potentially opens up all sorts of interesting further questions. What happens if after you record a conversation with Cafcass state in their report that it was indeed recorded, but you decide not to use it, but instead delete it? There is nothing to suggest in the letter that you have to keep any recordings you make. What happens if Cafcass themselves decide to record their interaction with you? Does that mean that they must then record their interaction with your ex for fairness and transparency? I think that we may have more to explore around this issue. However, for now, let's move on with what we do know. Cafcass state, if the Family Court Advisor is concerned that the recording will be shared with people who are not entitled to have access to it, they may wish to seek directions from the court. I understand that position, which makes sense. What is interesting is that it places a responsibility on us, the service user, to provide reassurances that we will not misuse any recordings made. So what about the notion of implied consent? We know that we can record covertly, but that may have problems in terms of admissibility. We shouldn't have to ask permission to record because we have a right in law to record interactions. So, let's see what Cafcass state about implied consent. Cafcass staff do not work on the basis that every interview and discussion they conduct will be recorded, and it is not accepted that there is an implied consent to recording in the absence of an objection expressed in advance. So, what they are saying is that although you have every right to record, they draw the line at assuming that the Cafcass Family Court Advisor does not have a right to object. Once again, I don't really have any problem with that. However, on what basis do they say that they can object? Let's find out. If an individual wishes to record a meeting, we hope that they would first inform the family court advisor of that intention, and in line with the guidance above, there should not be an objection, unless in the opinion of the family court advisor, it was likely to impact upon the quality of the discussions, or there was a real risk that the recording would be shared outside of the family proceedings. Now, that appears to give Cafcass some wiggle room and perhaps us some concerns as the service user, because any Cafcass officer, perhaps without any merit or evidence to back up their concerns, can just say, sorry, but it will impact on the quality of the interview, or that they have concerns that any recording may be inappropriately or unlawfully shared outside of proceedings. Personally, for that to be valid, they would have to clearly justify that concern. A concern itself is not sufficient. For example, if there is prior evidence that the service user has posted information on social media about the case, then that may be a justifiable concern because they cannot be trusted. In my opinion, the onus must be on the professional Cafcass Court Advisory Officer to justify any objection to lawfully recording an interaction. So what happens then if there is an objection by the Cafcass Court Advisor to being lawfully recorded? Cafcass explains, if no agreement is reached about the intention of an individual to record a meeting, then the issue may have to be referred to the court, acknowledging that this may cause delay and would only arise infrequently. Okay, I also understand that on one level. However, there are 2 points that Cafcass seem to have not considered. Firstly, why should the service user not refer the matter to the manager of that family court advisor? He must surely have the authority to direct that the interaction can be recorded. If the family court advisor still refuses, then in my mind that would be a clear disciplinary issue. Secondly, by their own admission, there is nothing to stop the service user recording the conversation covertly anyway. However, that may cause some problems in its admissibility. So, what would I do if I wanted to lawfully record a Cafcass interview or other interaction? And as a reminder, I am talking mostly about the safeguarding phone call and interactions in relation to the Section 7 report. Once again, you must not record any court proceedings or within a court building. That would be unlawful. Now, this is only what I may consider. I am certainly not telling you what to do in your own case. Firstly, prior to any interaction, I would inform the Cafcass Family Court Advisor in writing that I will be recording the interaction. I would advise them that I am recording rather than seeking any permission, because it is clear that you don't need their permission. As part of that written declaration, I would state something as follows. Let me read it out. Dear Family Court Advisor, in advance of our scheduled telephone call, I inform you out of courtesy that I will be recording the conversation in full. I may seek directions from the court to use a recording or an agreed transcript of the recording in proceedings if necessary. Please be reassured that this will in no way interfere with the quality of the interview and will not be shared inappropriately or unlawfully with any person outside of the court proceedings. In the event that I determine that the recording is subsequently of no evidential value or otherwise serves no useful purpose, then I will delete it without notice. In the event that you wish to raise an objection to the recording, I will refer this matter to your line manager. Please find attached a letter obtained from the head of your legal services by the Mckenzie Friend UK network in relation to lawfully recording Cafcass interviews and meetings. In the event of continued objections, I may in any event record the interaction covertly, as is my legal right to do so. I understand that you have the right to challenge the admissibility of any covert recordings in court. How brilliant is that? And I will even include this script in the downloads. Now, I promise to give my thoughts on the difference between overt recording, where you are transparent and open about recording Cafcass interactions, or covert recording, when you don't inform the Cafcass Court Advisor that you are recording. When it comes to covert recordings of Cafcass, there is a Court of Appeal case of Re Child B 2017, which concerns covert recordings being permitted or not in the family court. In this case, the judge, who was actually the then president of the Family Court Division, Sir James Mumby, concluded that there was surprisingly little authority and no adequate guidance on the issue of covert recordings. It appears that little has changed. My position is that I will always favour being open and transparent with Cafcass Court Advisors about lawfully recording interactions. Any decision to record covertly should, in my view, be a very last resort, if at all. Why? Because covert recordings could provide a court with greater concerns about its admissibility. Also, I believe that it is courteous and fair to be transparent. It builds better relationships and is the decent thing to do. So, the time has come to conclude, and I leave you with this thought. So many people contact me stating that they believe that the Cafcass Family Court Advisor has misrepresented them in reports and recommendations, which they state has had serious implications on their child arrangement case. My question to you is this: is it better to lawfully record a Cafcass interaction and not need it, than be faced with a relatively common situation that you didn't but now wish you had, because you need it? If you don't have a recording to establish exactly what was said, then there is very little comeback. Family court proceedings are perhaps one of the most stressful experiences of your life, which has far-reaching implications for you and the relationship with your children. Why then would you not take pragmatic steps to protect your interests in a manner that Cafcass themselves endorse as being totally acceptable and lawful? Recording Cafcass interviews and meetings is perhaps simply a sensible thing to do, and perhaps we need to get to a position where from this point forward every service user now does it as a matter of routine. From my perspective as a Mckenzie friend, it is also of huge value when supporting my clients to also be able to listen to that recording, especially if I cannot be present at the meeting or during any phone call, because with my extensive experience I can gather so much information from that recording. So, where can you download a copy of my original letter, the Cafcass letter of response, my suggested script, the Transparency Project guidance, and the case law? All you have to do is to look in the description box for the link or go to www.philsvlogs.co.uk and it's all there for you to consider in relation to your own case. Remember, I'm not telling you what to do. So don't forget to like, share, subscribe and hit that notification bell. I would love to read your comments, so let me know your thoughts. Catch up again very soon in my next vlog.